tell you the story of Harvey Hines. Harvey was a 16-year-old boy who went swimming with his friends in the Harlem River during the summer of 1916. Now, that river must have been a lot cleaner back then than it is now because the neighborhood kids swam there regularly. Someone had even taken a plank and nailed it onto a bulkhead adjacent to the river, and the boys used that as a diving board. So the bulkhead and the land on which it was built belonged to the New York Central Railroad. But the diving board extended over the river, which didn't belong to the railroad. It was a public waterway. The train at that location operated by means of high-tension electrical wires, which were strung along poles and held up by crossarms. So on this fateful day, one of those crossarms with electrical wires attached to it broke off the pole just as Harvey Hines stood on the plank ready to dive. The wires hit him, flung him from the diving board, and the fall killed him. The boy's mother, Florence Hines, believed that the railroad was responsible for her son's death. The railroad owned those electrical wires. It didn't maintain them properly, and as a result, these dangerous wires fell on her son and killed him. Now, the railroad's response was that it didn't owe anything to Mrs. Hines because her boy had trespassed on its land in order to reach that diving board. The railroad said that it didn't have an obligation to maintain its poles and the crossarms to protect trespassers on its land because trespassers weren't supposed to be there anyway. Mrs. Hines refused to accept the railroad's claim that it bore no responsibility to prevent this accident. Instead, she chose, like so many Americans before and since, to litigate. And in doing so, she helped shape the law. Today, Hines versus New York Central Railroad remains an influential opinion that most law students encounter in law school. But to make sense of it, you need to understand how to think like a lawyer. Once you learn how to do that, you will not only understand the law better, you will also have a better understanding of how to make an argument, even in a non-legal context. Thinking like a lawyer means mastering the ability to think actively and critically about legal doctrine. In law school, we teach this by asking students to read judicial opinions, like Hines versus New York Central Railroad, and then to talk with us about those cases. We ask them questions like, why did the judge decide the case this way? How does this case fit with other similar opinions that came before it? Would the case have turned out differently if particular facts were different? How would this opinion be applied to another hypothetical fact pattern? What's the best argument against this decision? And so forth. To answer those questions, law students learn to read cases looking for particular things. So one of those things is precedent. So let's start there. Legal analysis is a special way of thinking. So you may have noticed in real life that when you argue with a family member, your spouse or your kids, say, they're not likely to be persuaded that they have to do something because that's the way we've always done it. But when you are a lawyer making an argument to a judge, you will find that if you are advocating a position that no other judge has ever adopted, you are probably going to lose. That's the way we've always done it is actually a pretty powerful legal argument. And this gets into the notion of precedent. Precedent means following decisions that have been handed down in the past. So remember that America's is a common law legal system. As we've discussed, this means that what judges say about a statute is every bit as important as the statute itself. The opinion a judge writes about the statute becomes part of the law too. So because of this, other judges deciding a case have to look both at the statute at issue and at what other judges have said about that statute. If the issue has been decided in the past by the court hearing your case or a higher court in that same jurisdiction, then the matter is settled, even if the result in your case seems preposterous. This principle is known as stare decisis, which is a Latin phrase that means to stand by things decided. You have to follow past precedent, even if you are a judge and you don't like the result that will occur. So to some people, this idea seems awfully rigid. Why would we create such a system? Law is fundamentally conservative so that people trying to follow the law will know what to expect. If the law could just change at the mere whim of a judge, then society would be so unsettled that people would not know how to behave. Law is also conservative to protect people from being treated unfairly by judges who don't like them. Requiring a judge to follow precedent makes it more likely that the law will be applied consistently, not according to the whims and prejudices of individual judges. That is essential to a system governed according to the rule of law, which is a hallmark of a free and fair society. In addition, the law is conservative for purely practical reasons. If judges were asked to decide every legal issue in every single case from the beginning, every single time, the workload would be overwhelming. Supreme Court Justice Louis Brandeis explained it like this. He said, "In most matters, it is more important that the question be settled than that it be settled right." Now, that may sound terribly unfair to the parties, but it would also be unfair for everyone if the courts got so bogged down that you couldn't get a hearing for years and years because judges were deciding things anew in every case, every time. So, when a lawyer is reading a case, he or she will keep an eye out for a discussion of precedent. This will usually involve the judge citing older cases and comparing them to the decision at hand. The judge will try to explain why the two cases are similar, which means that the precedent binds the case at hand and dictates its outcome, or why they aren't. Note that precedent means that the case has been decided in the past either by a judge in the same court, which is called horizontal precedent, or by a higher court in that same jurisdiction, which is called vertical precedent. We talked previously about how we have various court systems, state courts, federal courts, and so forth. So if a case was decided by a court in a different jurisdiction, in the state next door, for example, that court's opinion might be informative, but it wouldn't be precedential. The court deciding your case would be free to reject it. Lawyers sometimes talk about this as being persuasive authority, but it's not binding authority. Now, of primary importance in any case, naturally, is what the court decided in the dispute at hand and why. This is known as the holding of the case. Anything else that the court said that isn't actually essential to resolving the matter at hand is called dicta. The holding of the case is what judges will follow in subsequent cases, and it's binding. The dicta, while informative, is not binding. So, for example, the holding of a case might say that the defendant broke the law by driving a car through a public park. So the judge might also have spent some time in that decision musing over whether the outcome might have been different had the defendant driven a scooter through the park. But if the actual case didn't involve a scooter, this musing would be classed as dicta and it wouldn't be binding. A court deciding a scooter case wouldn't have to follow it. If you can find binding authority to support your argument, you are on firmer ground than if you were to point to dicta or to a secondary source like an academic article written by a law school professor, which no judge is ever required to follow. If you want to rely on non-binding persuasive authority, then you will need to be able to articulate why that authority is credible. The more credible the authority, the more convincing your argument will be. So here's another thing that is central to the notion of thinking like a lawyer: textual analysis. Legal analysis can sometimes seem peculiar in the way that it emphasizes the exact words of a statute or a constitutional provision or a case. A lawyer has to pay close attention to the text of the legal rule or the precedent governing the case. When you make a legal argument, it is not going to be sufficient to paraphrase the language. Very often, the best legal argument will be the one that parses the words the most carefully. Along the same lines, the judicial system is devoted to adhering strictly to the text of rules. You can see this, for example, in the application of a filing deadline at a courthouse. So the rule might say that a brief must be filed by 6 p.m. on a particular day. Now, the original motivation for this rule might be to keep the employees in the clerk's office from having to work past 7, or to make sure that the brief is on the judge's desk in a timely fashion. Whatever the case, if you arrive at the courthouse at 6:05 and attempt to file your brief, you will be turned away. Now, you might argue that there's very little difference between 6 and 6:05, that there was a really good reason why you were late because you were rescuing a child from a burning building. Oh, and that the clerk won't have to work late because you would be happy to walk the brief up to the judge's chambers yourself. But your arguments are not going to succeed. The rule is clear, 6 p.m. Doesn't matter what the purpose of the rule was, or if you have a good reason why the rule shouldn't apply to you. Clerks' offices are very good at enforcing rules, and rightfully so. They don't want to be in the business of deciding who has to follow the rules and who should get an exception. So that wouldn't be fair. So a clerk's office rule is what is known as a bright line rule. The requirements are clearly stated and inflexible. So a bright line rule is something that you see quite a lot in various laws and in legal opinions. Now, what happens when the text of a rule is less clear? So let's take, for example, the text of the Second Amendment of the U.S. Constitution. The Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that text, read literally, seems to draw a connection between the necessity of having a well-regulated militia and the right to bear arms. It could be interpreted as saying that the people have the right to bear arms if they are going to be part of a militia. But we now understand the Second Amendment to mean that Americans have the right to bear arms regardless of whether they're serving in the militia or not. The Supreme Court said so in a case called District of Columbia versus Heller. So the Second Amendment is an example of a text that could be interpreted literally, but isn't. So a typical Socratic dialogue in law school might involve a professor asking one student to take one position about the meaning of the text and another student to take the opposite position. So one student might then rely on the plain meaning of the words, the other student might look at the purpose of the provision or how it fits into other parts of the law. So as a lawyer, you might argue based on the letter of the law, or you might argue based on the intention behind the law. Either way, you cannot ignore the text. Another concept that is central to thinking like a lawyer, understanding the use of analogy. Lawyers often rely on analogy to make a point. So that is, they point out how a case is similar in some way to some other case, and then argue that the two cases should therefore be decided in the same way. Now note that analogy is not always the same thing as precedent. If you can draw an analogy with a case in the same jurisdiction, you may be able to establish that the case is binding, but you can also analogize your case to similar ones that don't exactly control it. Cases in a different jurisdiction, for example. So to use analogy well, you start by laying out the facts of your case and the facts of the case that you want to compare it to. So for example, your case might involve a farmer who is being sued for the damage that his cow caused to his neighbor's field. And the case you're comparing it to might involve a zookeeper who was held liable because his lion ate a tourist. And then you compare the facts of the case. You emphasize the similarities that are relevant. For example, both cases involve wild animals that have been housed negligently. And then you throw away the ones that are not relevant. So for example, does it matter that one victim was a field and the other victim was a person? If the cases are similar in central ways, then the cases should result in similar outcomes. Now, of course, you need to be ready for the likelihood that opposing counsel will challenge your analogy, arguing that the facts that you called irrelevant actually make the case you're citing inapplicable to the one at hand. All right, now let's turn to the topic of logic and legal arguments. Many legal arguments are based on the sort of deductive logic that Aristotle spelled out a long time ago. You can figure out the right outcome if you can identify the correct legal proposition and apply it to the facts at hand. Aristotle explained this in the form of a syllogism in which you have a major premise and a minor premise, and together they point the way to a conclusion. So if A is true and B is true, then C must be true. So here's his famous example. All men are mortal beings. That's your major premise. Socrates is a man. That's the minor premise. Therefore, Socrates is a mortal being. That's the conclusion. So if you apply this to a modern-day legal example, anyone who takes an item from a store without paying for it has committed larceny. That's your major premise, your rule of law. John took a necklace from the store without paying for it. That's the minor premise, the facts of your case. Now you're going to apply the law to those facts, and you come up with John has therefore committed larceny. That's the conclusion. So you have to pay attention to making sure that your major premise is true. If it isn't, then your conclusion is going to be flawed. So let's look at that larceny example again. Common law defines larceny as taking, not from the person, with the intent to permanently deprive the owner of the item. So let's imagine that the store in question was on fire, and John was actually one of the firefighters who grabbed some valuable items in an effort to save them. In that case, it seems wrong to say that he committed larceny. The erroneous conclusion that John committed larceny arises from a misstatement of the major premise. That is, a misstatement of the law of larceny. So a better analysis of the case would be anyone who takes an item from a store without paying for it, intending to permanently deprive the owner of it, has committed larceny. John took a necklace from a store without paying for it, but intended to return it to the owner. Therefore, John has not committed larceny. So that's deductive reasoning. So Aristotle also wrote about the power of inductive reasoning. Inductive reasoning means that you use a bunch of specific observations to draw a broad generalization. This can be a useful sort of argument when it is difficult to prove something. So, for example, a lawyer might need to argue that a certain kind of medicine does not harm women. It's hard to prove a negative. But if you can show that lots of women took the medicine and weren't harmed, your claim might be credible. Now, your argument is going to be more compelling the greater the number of known observed facts you have and the more reliable they are. If you try to argue that medicine doesn't harm women because your sister took that medicine and she wasn't harmed, that clearly is not going to be as persuasive an argument as one based on hundreds of women taking the medicine might be. So if you make an argument based on inductive reasoning, you probably shouldn't rely only on your own personal experiences. Instead, you would want to draw upon a large enough number of examples from which you can generalize. You'd also want to think about how your sample could be criticized. So for example, if I drew a sample from the people at the university where I teach, that might not be representative of the population at large. It might include too many college-aged people. So that is how a lawyer might attack the testimony of an expert witness as well. If the sample upon which the expert bases his opinion is flawed, then his opinion won't be credible. Okay, so those are important ideas to master to be able to think like a lawyer. So let's apply these ideas that we've been exploring to Hines versus New York Central Railroad Company. So the opinion in the case was handed down in 1921 by the New York Court of Appeals, which is the highest state court in New York. And it was written by Benjamin Cardozo, famous judge. He was a state court judge at this time, but he eventually became a United States Supreme Court justice. And he was the second Jewish person to serve on the Supreme Court. Justice Cardozo was known for his belief that the law should meet the needs of real people in the real world. He wanted judges to pay attention to public policy when deciding cases. You can hear Justice Cardozo's concern for people and public policy in his approach to the Hines case. He starts his opinion recounting the facts from the point of view of Harvey Hines, a lad of 16, and the boys with whom he went swimming. When he describes the diving board, he emphasizes, and here I'm quoting him, "For more than 5 years, swimmers had used this as a diving board without protest or obstruction. And for 7.5 feet, the springboard was beyond the line of the defendant's property and above the public waterway." Cardozo goes on to tell the story very vividly. Here's what he says. "On this day, Hines and his companions climbed on top of the bulkhead intending to leap into the water. One of them made the plunge in safety. Hines followed to the front of the springboard and stood poised for his dive. At that moment, a crossarm with electrical wires fell from the defendant's pole. The wires struck the diver, flung him from the shattered board, and plunged him to his death below." So one can imagine that the railroad might have stated the facts differently. It might have preferred the judge to say something about how this is a case about the New York Central Railroad, which operates its trains by high-tension wires strung out on poles and crossarms. And it might want the judge to point out that railroads are dangerous and that danger is obvious. Maybe it would want the judge to say, despite the obvious danger or perhaps attracted to it, teenage hooligans like to trespass on railroad land. On this particular day, a teenager named Harvey Hines and some other teens came uninvited onto railroad property and were leaping from the shore into the water. Through no willfulness on the part of the railroad, Hines was killed in an accident when an electrical wire fell on him. If he had not been on the property where he was not permitted to be, he would not have been injured. Clearly, how one views the facts of a tragic incident can govern whom one holds responsible for it. A law student might be asked to recite the facts in the light most favorable to the railroad or to Harvey Hines's estate, laying the foundations for a case either about trespass and delinquency and an obvious danger, or about a lad of 16 out for a swim. According to Judge Cardozo's opinion, the lower court, which found for the railroad, and the judgment of which Cardozo is reviewing, started with the premise that the railroad didn't owe a duty of care to a trespasser. So that means it didn't have to regulate its conduct on its own private land to protect people who entered that land uninvited. The issue for the lower court, according to Cardozo, was whether, and here I'm quoting, Hines at the end of the springboard above the public waters was a trespasser on the defendant's land. So, the rule in that analysis, landowners don't owe a duty to trespassers. Application of this rule to this case, Hines was a trespasser because he entered the land without permission. Therefore, conclusion, the railroad did not owe a duty of care to Hines. So you could think about the lower court's logic in terms of one of Aristotle's syllogisms. Major premise, no duty of care owed to trespassers. Minor premise, Hines is a trespasser. Conclusion, no duty of care owed to Hines. Justice Cardozo thought the lower court got both the major and minor premises wrong. He said that this wasn't a case about trespassing at all. This was a case about the duty of care that the railroad owes to the public in a public space when the railroad's equipment moves into that space. According to Cardozo, the diving board extended out 7.5 feet from the railroad's property into the river, which is a public waterway. Because Harvey Hines was on the diving board in the air over the river, he wasn't on the railroad's land at the moment of the accident. He was in a public space. Cardozo writes, bathers in the Harlem River on the day of this disaster were in the enjoyment of a public highway entitled to reasonable protection against destruction by the defendant's wires. So the logic of this opinion goes like this. Major premise, the railroad owes a duty of care and vigilance in the storage of destructive forces, the electrical wires, to the public using a public space. Minor premise, Hines was a member of the public using a public space, the river. Conclusion, the railroad owed a duty of care to Hines. So here's an interesting thought, though. Hines seemed to have trespassed on the railroad's land to reach that diving board. So if those electrical wires had fallen on Hines as he approached the diving board, when he was squarely on the defendant's land and trespassing, would the railroad have owed him a duty of care? Probably not, because then he wouldn't have been in a public space. But since he was on the diving board and the diving board extended above the water, the railroad is on the hook. In Cardozo's analysis, the way that Hines got to the diving board doesn't factor in at all. Cardozo writes, landowners are not bound to regulate their conduct in contemplation of the presence of trespassers intruding upon private structures. Landowners are bound to regulate their conduct in contemplation of the presence of travelers upon the adjacent public ways. So notice that the first sentence, landowners are not bound to regulate their conduct in contemplation of the presence of trespassers intruding upon private structures. It's not the holding of the case. Now, it sounds like a clear pronouncement of law, but it is dicta, because in Judge Cardozo's analysis, this wasn't a case about a trespasser intruding on a private structure. Cardozo says this is a case about a boy using a public waterway. So even though that first sentence sounds like a ruling by a court, and even though it might be persuasive because Cardozo said it and he's famous, it is not the holding of the case. It's not going to bind other courts in this jurisdiction. You could find a different case to stand for this proposition, but you can't use this one. Now, the second sentence is the holding of the case. Landowners are bound to regulate their conduct in contemplation of the presence of travelers upon the adjacent public ways. So, if you are a lawyer bringing a suit in this jurisdiction, New York, and you are suing a landowner who is doing something that affects public spaces, flooding a road perhaps, or throwing things into a river, then this case helps you. The judge deciding your case will have to take as his starting point the law is handed down by Judge Cardozo, that landowners can't do things to hurt the public on public property. That's the part of the case that will serve as precedent for cases that follow. Now, if you are representing the landowner, you could try to narrow that holding. You could argue that Hines is specifically about dangers to the public involving electrical wires, and therefore doesn't apply to your case, which involves none. That would be a fair argument. The court would have to think about whether electrical wires and flooding a road are the same thing, in that they can both potentially harm the public, or if they're different because electrical wires are inherently dangerous. So that is the sort of thing that a law school professor is likely to ask about in class. It's also interesting to see how Judge Cardozo uses analogy in this case, because it gives you a window into how lawyers argue. At one point in this opinion, Cardozo imagines this scenario. He writes, "Two boys walking in the country or swimming in a river stop to rest for a moment along the side of the road or the margin of the stream. One of them throws himself beneath the overhanging branches of a tree. The other perches himself on a bough a foot or so above the ground. Both are killed by falling wires. The defendant would have us say that there is a remedy for the representatives of one and none for the representatives of the other. We may be permitted to distrust the logic that leads to such conclusions." So his point is that the outcome would be absurd. The location of the two boys is essentially the same, under the tree or up in the tree, so the remedies shouldn't be different. Similarly, Hines's remedy should not turn on whether he was on the diving board or in the air above the diving board or in the water below the diving board. The lower court's ruling implies that Hines's estate could recover if he was under or over the diving board and therefore in public space, but not if he was on it, since it's attached to the railroad's land. Cardozo thinks this makes no sense. He writes, "Hines would have gone to his death if he had been below the springboard or beside it. The wires were not stayed by the presence of the plank. They followed the boy in his fall and overwhelmed him in the waters." So the Hines case gives you a sense of how litigation shapes the law. Through this particular dispute, the shape of the law for everyone changes. The railroad is now more likely to make sure its electrical lines and crossbeams are in good repair, but that change in behavior will not be limited to the railroad. After this decision, all landowners adjacent to public waterways in this jurisdiction would have to take care that their activities don't cross into those waterways and hurt the public. And yet, notice how Justice Cardozo carved out a space to find a fair outcome in this case without completely upending the established right of property holders to make use of their land as they please without a duty toward any and all trespassers. He's refining the law, but he's also seeking to uphold it. As you continue thinking about the law, consider what we've talked about in this discussion of thinking like a lawyer. It will help you make sense of what you're reading and give you a framework for thinking about why cases come out the way they do.